Hey, Prime members! Are you tired of ads interfering with your favorite podcasts? Good news! With Amazon Music, you have access to the largest catalog of ad-free top podcasts included with your Prime membership. To start listening, download the Amazon Music app for free or go to amazon.com/ad-free podcasts. That's amazon.com/ad-free podcasts to catch up on the latest episodes without the ads.
Imagine you're a business owner relying on a dozen different software programs, each one disconnected, more expensive, and more complicated than the last. It can be incredibly stressful, right? Now, picture Odoo. Odoo brings all the tools your business needs into one simple platform. CRM, accounting, inventory, manufacturing, marketing, HR, and more. All seamlessly connected. Everything works together, giving you the peace of mind that your business is running smoothly from every angle. Odoo's open source applications are user-friendly and designed to scale with your business, saving you time and money. Say goodbye to juggling multiple platforms and hello to efficient, integrated management. Stop wasting resources on complicated systems and make the switch to Odoo today. Visit odoo.com, ODOO.com, and discover how Odoo can simplify and streamline your business operations. Odoo, modern management made simple.
Do Lyle and Eric Menendez have a shot at freedom?
Your recommendation to the court would be to not grant a new hearing.
It's inconceivable that if the letter actually existed circa 1988, that they wouldn't have introduced its contents to further corroborate this sexual abuse testimony.
On the petition for clemency, if the governor of California granted that, they could be released immediately.
Done. No hearing, no appeal, just you're done.
Tonight, I'm diving into a dark chapter of American crime history that shook Beverly Hills and the country with the help of former Los Angeles prosecutor and Merit TV's own Lonnie Coombs. But first, the Menendez family had it all: wealth, status, and a mansion in one of the most exclusive neighborhoods in the entire country. But on August 20, 1989, their picture-perfect facade came crashing down in a hail of gunfire. Jose and Kitty Menendez were relaxing in their den watching TV on what seemed like an ordinary Sunday evening. Little did they know their own sons, Lyle and Eric, aged 21 and 18, were about to unleash a brutal attack that would forever change the course of this family. The crime scene was nothing short of horrific. Jose was shot point blank in the back of the head, while Kitty, in a desperate attempt to flee, was gunned down with multiple shots. The once pristine living room was now a gruesome scene of violence with over a dozen shotgun blasts, leaving a haunting mark on the walls and their victims. At 11:47 p.m., a frantic 911 call pierced the night. On the other end of the line was a hysterical Lyle Menendez, barely able to form coherent sentences through his sobs.
Beverly Hills emergency?
Yes, please.
What's the problem? What's the problem? What's the problem?
I'm trying to kill my parents.
Pardon me? What? Who? Are they still there?
Yes.
The people...
No.
Were they shot?
Get away from me.
Were they shot?
Yes.
They were shot?
Yes.
102 North Elmore.
What happened?
I have a hysterical person on. We're trying to get screened further. Other units responding. Is the person still there?
What happened? We have units around. What happened? Who shot who?
I don't know.
You came home and found who shot?
Mom and Dad. You know if they're still in the house, the people that did the shooting.
Get away from me. Okay. Hey, let me talk to Eric. Who is the person that was shot?
My mom and my dad.
Your mom and dad?
My mom and my dad.
Okay. Okay, hold on a second. Okay, we're on our way over there with the ambulance. Okay, I gotta go.
Little did the authorities know this call would be the beginning of a case that would captivate the nation for years to come. I sat down with the new Los Angeles District Attorney, Nathan Hochman, just after he got his new job and asked him what he thought he was going to do with the Menendez case. Is there new evidence?
The new evidence has been alleged by the defense as to a letter that there is between Eric Menendez and his cousin that was sent months before the actual shooting back in 1989. And then there was another form of evidence of another individual that was saying that they were sexually abused by the Menendez's father.
Has the letter been authenticated, that it was written by Eric?
We never received the original of the letter, and we're evaluating it.
And does the original exist? Do they know?
The original has never been produced by the defense.
I see. Speaking hypothetically now, was this information available at the time of the original trial?
Again, that is another fact that we're determining on whether or not it meets a very rigorous standard for habeas review, which would get them a new trial.
Yeah. If it was available but not presented, does that meet the habeas standard, or would they have to come with some proof that they had inadequate counsel if they didn't find it and present it?
You could always try an ineffective assistance of counsel defense, but that would follow the analysis as to whether or not the information's actually new. So the first thing you'll determine is whether or not it's new, whether or not it meets the elements, and they're pretty rigorous to get a new trial. And if that's denied, then the defense may go ahead and look at the issue as to whether or not their counsel properly presented it in the first place.
In a recent development, District Attorney Nathan Hochman has taken a firm stance against granting a new trial for the Menendez brothers and has asked the court to deny Eric and Lyle Menendez habeas corpus petition.
The Menendezes have already had their direct appeal through the California Court of Appeals and California Supreme Court, and they have lost. They've even had one level of California habeas, which they lost, and one level of federal habeas, which they've also lost. So now they've come back for a second California habeas petition. And in coming back for that, they have basically said there are two new pieces of evidence, along with their arguments, that justify them getting a new trial. Is this credible evidence? We argue in many different ways it is not credible evidence, which is why we conclude in our informal response that the court should deny the current habeas petition by the Menendez brothers.
Following his pivotal press conference, I spoke with District Attorney Nathan Hochman regarding the Menendez brothers case. Well, D.A. Hochman, thank you so much for taking the time to talk to me.
My pleasure. Great to see you again.
Well, it's good to see you again. I listened to your press conference about the Menendez brothers, and I guess my first question is, from the standpoint of you as the DA and from a habeas standpoint, from the legal standpoint, it doesn't sound like this was a close call after you studied this case.
That's correct. The habeas petition involves whether or not the new evidence compels a new trial. So to get a new trial after you've already been through all the appellate process, I mean, this particular case went to the California Court of Appeals, the California Supreme Court, the federal U.S. District Court, the U.S. Ninth Circuit. To get a new trial at this point, you gotta jump through some very high hoops. And the new evidence that they presented, which was an undated photocopy of a letter between Eric Menendez and his cousin, supposedly December 1988, that had never seen the light of day until 2023 or 2015, wasn't a close call as far as being a timely, credible, admissible piece of evidence, nor was the Roy Rossello declaration where he alleged that he had been sexually molested by Jose Menendez in the 1980s, because both Menendezes admitted that they didn't find out about this till the 2020s not back when they were shotgunning their parents to death in 1989. So it couldn't have played any role whatsoever in their mental state when they engaged in these murderous actions.
Right. And one thing I want to bring out, you and I have talked about this before, but I want to be very clear. I'm not suggesting that you gave me any preview of this case or how you looked at it at all, other than you're telling me that your intention was you were going to go through thousands of pages of testimony and evidence and records before you took any position on this case whatsoever. So this wasn't a knee-jerk response by you as Los Angeles District Attorney. You really did your homework and reviewed thousands of pages of testimony, trial records, evidence, as well as the applicable law on this. So you really did your homework on this. Is that a fair statement?
Absolutely. I engaged an entire team. We went through over 50,000 pages of 2 months-long trials. We spoke to Menendez family members, everyone that wanted to speak to us, defense counsel, prior prosecutors in the case. We did our best to do our homework. We filed almost a 90-page brief today as an informal response required by the court in connection with this habeas petition. So we've done our best to dig deep into the trial record so that when we wanted to credibly say that this new evidence would not have likely affected the outcome of the trial, we could say that confidently.
And, people talk about the Menendez brothers as though this is one case. And you made a great point to me when we talked about this a few months ago, that this is not one case. They went to trial together, but there were two very different tracks here. This is not one case. These are two separate brothers, two different sets of evidence, actually two sets of charges. So these were not mirrors, and they had two different sets of evidence that had to be considered. So these were not identical charges. These were not identical sets of evidence, correct?
That's absolutely correct. In the criminal justice system, everyone is considered an individual. So even though we talk about the Menendez brothers, it's really Eric Menendez separate from Lyle Menendez. Now, in great respects, they acted in a coordinated fashion. In fact, they were charged with a conspiracy to commit this murder. But the other part that we have focused on is that it wasn't just one, but two different people that they killed. They killed Jose Menendez, which means they had to have an actual fear of imminent harm from Jose Menendez the night that they killed him in order to justify their self-defense. But they also had to have that same feeling, that same actual fear of imminent harm about Kitty Menendez that same night.
Now, this, as I understand it, their lawyer at the time did not plead that sexual abuse was a defense. That was not a constructive defense that was pled to justify the killing of these parents. Is that right?
That's absolutely right. Leslie Abrahams, she said this sexual abuse does not justify a killing, that it was an argument she wasn't making and never would. 30 years later, Eric and Lyle Menendez, new counsel in this habeas position, said there's only one critical issue. Were the boys molested by Jose Menendez? So Leslie Abrahamson understood correctly that the issue before the jury wasn't sexual abuse. It was, did they have an actual fear at the time of imminent harm? Basically, their parents were going to shoot them that justified shooting them first, or was this a premeditated, willful, deliberate murder, which is what the jury found for both Menendez, for both victims.
And if that had been a defense at the time, then I suppose the prosecutor would have tried a very different case, because there would have been a lot of alternative explanations. They could have run away. They could have called social services. They could have asked for help. There were a whole lot of alternatives besides shotgunning them 12 times. And so a different case would have been presented if that had been offered as a defense, or if they had pled self-defense and with regard to the sexual abuse. And in fact, the evidence didn't support that. For example, the father was shot in the back of the head, which doesn't suggest he was coming at them and causing them to feel imminent danger at the time.
You're mostly right, Dr. Phil, but they did try to link the sexual abuse to self-defense. It's just it failed. But they said that they had been abused, Eric for almost 12 years, Lyle for 2 years, by the father. And then they said that Lyle apparently went to the father and said that if you continued abusing Eric, he was going to expose to the public and the police what had done. And the father basically let it be known that that would be a bad decision for Lyle. However, the problem with their defense is that there was nothing that had happened that night that showed that there was an imminent threat that night that the parents were going to kill them. In fact, so much so that the parents were in the den watching TV. The boys ran to their rooms, grabbed their shotguns, loaded them, shot their parents, killed dad immediately, didn't kill mom, ran back to their car, reloaded the shotgun, and then Lyle put the shotgun against their mom's face and pulled the trigger. So the jury had plenty of evidence to show, including their pre-planned alibi. They're obtaining the shotguns days before using a fake ID and address. The stories they eventually come up with, their denials to the police as to what happened, their failure to even raise a sexual abuse defense for over a year. They had all this information to show that the story about there being an actual fear of imminent harm was just that, a story, and not based on the evidence.
Well, they had 5 stories originally. Is that correct? First, they didn't do it. It was a mafia hit. Then they were violated sexually. Lyle had been raped by someone from the outside, and then that the father had raped Eric and the mother had raped Lyle. And then Eric and Lyle had both been abused or raped by the father, and then the parents were going to kill them. That was the 5th story. Is that right? They kept rotating to a different story?
Yes, and that's exactly right. The story kept evolving over time, depending on whether or not they got caught and what they actually needed to plead in order to have a legal defense at trial. So when they realized that just saying you were sexually abused wasn't enough to justify the killing, then they had to extend the story. They had to say, not only were we sexually abused, but sure enough, our parents, and not just Jose, but Kitty as well, threatened to kill us, which is why we had to kill them first. Problem is the jury didn't believe that linkage, that they actually faced that actual fear of imminent harm, and convicted them each of first-degree murder.
Yeah. Now, does all of that go to the credibility of them now coming up with this story about the letter and not knowing about it previously? And does admissibility come into play with this being a photocopy and not an original? Does all of that play into the admissibility of this evidence at this stage of the game?
Absolutely. The habeas petition, which is the one that we dealt with today, is basically saying that we need to overturn a trial that has been affirmed by a jury, a judge, and every level of appeal that's seen it, in order, because we have new evidence that is timely, that was admissible and credible. And we go through each of those factors with each of these new pieces of evidence and say it doesn't meet the standard. So for instance, they're saying that this letter from Eric to his cousin Andy Kano was supposedly written in December of 1988. Problem is, Eric and Andy Kano both testified in both trials in 1993 and 1995. They said that the last time they had talked about sexual abuse was when Andy was 10 and Eric was 12 or 13. This would have been 6 years later. So we basically said it's inconceivable that if the letter actually existed circa 1988, that they wouldn't have introduced this letter and its contents at trial to further corroborate this sexual abuse testimony. And Eric basically says that he didn't learn about the letter till 2015, as did Lyle. The law says you cannot engage in substantial delay once you have a new piece of evidence and presenting it to the court. Moreover, he had a situation where we said that the letter is part of this continuum of fabricating stories that started days before the murder when they got the shotguns using a fake ID through their pre-planned alibi to try and make it look like Jose was a violent rapist, that they tried to get a handgun ahead of the murders because they feared for their lives, and that mom was trying to supposedly poison the whole family.
Any one of those elements could preclude this evidence from being considered by the court under this habeas petition now. Is that a fair statement?
Yes, that is a fair statement.
So at this point, with all of this being called into question, your recommendation to the court would be to not hold a hearing and to certainly not grant a new hearing based on what they're now calling new evidence.
That's exactly right. But this is the one that was designed to get them a new trial. They also have out there a clemency petition directly to California's governor, asking them to commute their sentence and release them immediately. The third track is something called resentencing. But that's to actually get a new sentence, effectively go from life without the possibility of parole to life with the possibility of parole.
Do you have any evidence, any idea what the governor is likely to do with the clemency petition?
Most recently, he has said he was waiting to see what I end up doing with the case. So hopefully he'll read my 88-page submission from today.
We are moving forward with an investigation, a risk assessment investigation that I've directed to the Board of Parole Hearings so that we can make a determination as to whether or not to move forward with the clemency request that came from Menendez attorney.
Well, DA, I know you're very busy. A lot of people are wanting to talk to you, so I don't want to overstay my time here. So thank you so much again for granting me this time to talk about this very interesting case. I know America's been watching it closely, and I look forward to talking to you again soon. And I hope everybody in LA is hanging in there with the fires and the rehabilitation from all that. And we appreciate your leadership on that front as well. So thank you very much for taking the time to speak with me.
I very much appreciate it as well. Look forward to the next opportunity.